Hey everyone, we'll get started here in just a second. Hi there. Thank you for joining us today for the DAYL CLE on mechanics liens. My name is Bobby Hill. I'm a litigator at King and Spalding. A quick preamble before we get going. Today's CLE is approved for 1 hour of CLE credit, and the course number will be posted in the chat near the end of the program. Should you have any questions for our speaker, please use the Q&A feature at the bottom of the window. Now, without further ado, I am pleased to introduce Caden Watts as our speaker. Caden works at the Pettit Law Firm in Dallas, Texas. He received his undergraduate degree from Stephen F. Austin University in Nacogdoches, Texas, where he double majored in philosophy and criminal justice. Caden then went on to study law at Louisiana State University in Baton Rouge, Louisiana. While there, he interned at the Louisiana First Circuit Court of Appeal and also briefly interned for our very own Judge Martin Hoffman of the Dallas 68th Judicial District Court. Caden, welcome.
Thank you, Bobby. I really appreciate the intro there. Now, as Bobby mentioned, my name is Caden Watts, and I am an associate here in Dallas at the Pettit Law Firm. So I work with Julie Pettit, David Urtiago, and the rest of the fine folks here at the firm. And our main practice area includes real estate litigation, general business litigation, and personal injury. Now, I've been with the firm for a little over 4 years. And over the past year or so, I felt like I'd seen an uptick in either potential new clients or existing clients reaching out and asking questions about mechanics liens or asking for assistance with mechanics liens. So whether that be a contractor who needed a lien filed or a property owner who had a lien filed against their property and contacted us and said, hey, what do I got to do here? What's needed from me? Is this even valid? How do I make this go away? So with that in mind, I created a short presentation for the firm that was really just tailored to residential homestead mechanics liens or mechanics liens, excuse me, on residential homesteads. Little did I know that was going to be the skeleton for the CLE today, and we've expanded upon that here. So my goal today is to provide you with a summary of information related to perfecting a basic mechanics lien at the foundational level. So just, like the properties that liens attach to, the buildings are often only as strong as their foundation. So hopefully, by the end of today, you'll have a solid foundation to prepare you to either build or deconstruct any mechanics lien matter that you may face in your own practice. So let's just begin by discussing some of the basic questions surrounding mechanics liens and then their answers. So what are mechanics liens? Where do they come from, and which statutes do we look to when interpreting mechanics liens? So in their simplest form, mechanics liens are just a way to recover or at least assert a right to payment for unpaid work or materials provided in furtherance of a private construction project. So the Texas Supreme Court has held that mechanics liens have their basis on equitable principles, and this makes sense. When a person increases the value of another's land by providing improvements, the improvement should be paid for. Seems right. And the person making the improvement should, to the extent of the contract price or the value of those services or materials, have a lien to secure or a lien against the land to secure that payment. So perfecting a mechanics lien gives you a number of benefits. First, a perfected lien creates a cloud on the title of that property. It also alerts others to the alleged debt, such as potential lenders or potential buyers. And this could affect that property owner's ability to sell the property or to obtain funding for projects related to the property. Furthermore, pursuing that lien procedure provides an added benefit of just creating a strong negotiation tool. And that can help give a contractor the upper hand when requesting payment before litigation. So watching a contractor perfect his right to lien a property can be sobering for any property owner or an original contractor if the claimant is a subcontractor. So following these lien procedures correctly, and either by serving that pre-lien notice if required or then filing a lien affidavit, can really support resolving any dispute regarding unpaid debts before and hopefully without the need for costly and time-consuming litigation. Additionally, just as a practical tip, um, pursuing this lien procedure is going to clear the air on just what exactly is in dispute before litigation. So before you even draft a petition or have a petition drafted against you, you're going to understand what amount someone's claiming they're owed and for what specific work relates to that debt. Lastly, there is no downside to filing a mechanics lien. So the mechanics lien process does not limit a person's ability to pursue any unpaid debt by way of breach of contract or other cause of action, but rather can be asserted in addition to these claims. So the Texas Supreme Court tells us that mechanics liens are creatures of statute and that there's two sources for mechanics liens in Texas, Article 16 of the Texas Constitution and Chapter 53 of the Texas Property Code. Now, while I just mentioned that the Constitution does provide liens for certain contractors, most of today's presentation is going to focus on mechanics liens that are created under Chapter 53. The Texas Supreme Court previously described the statutes governing mechanics liens as, quote, very lengthy, the subject of several revisions, and lastly, my favorite, not exact models of clarity, but then again, what statute is. And now, although this description was aimed at the prior version of Chapter 53, which used to be known as the Hardman Act, I still think that this description applies to today's versions of the statute. So hopefully, by the end of the day, you're going to have some clarity in building or deconstructing any lien that you face, or at least know where to look. So let's first look to Chapter 53. Now, Chapter 53 is going to give you the majority of the tools you'll need when dealing with any mechanics lien matter. And there's 12 specific subchapters relating to mechanics liens under Chapter 53, but I've highlighted 4 here on the screen that I think are most important for perfecting a basic lien or to be used when determining whether any lien that's been filed is valid or not. So subchapter A is your general provisions section. This is going to give you, this includes a section on definitions that are repeatedly used throughout Chapter 53, and there are quite a bit. So I think it's always best practice just to pull up this definition section and take a look and make sure you have that there as a reference as you're reviewing the rest of Chapter 53. It also gives you some information on how notice can be delivered and the timeline for calculating those deadlines. Subchapter B is your who's and what's of mechanics liens. It's going to tell you who's entitled to a lien and to what property a lien can attach. Subchapter C is your hammer and your nail. This is going to tell you the procedure for perfecting your lien, such as the procedure for pre-lien notice, if required, and then the procedure for that lien affidavit. Subchapter K includes some additional procedures for residential projects, so I think it's important to reference in case you are dealing with the residential construction project. There's going to be additional requirements provided there. Now, before you worry about perfecting a lien or whether a lien has been perfected, I think this question here is often overlooked, and that's, is this person even entitled to a mechanics lien? So Chapter 53021 tells us that a person has a lien or is entitled to a lien, excuse me, if that person under a contract with any of these individuals listed on the screen provides any of these following 5 types of services. So the first is if they provide labor or furnish labor or materials for construction or repair of an improvement. And this is going to be your typical contractor that you're going to see. This is your generic contractor. I think most will be covered by this first type of service. Now, the second type of service is if they specially fabricate materials for a job, even if those materials are not delivered. Now, specially fabricated materials is a defined term under subchapter A, and it just means that materials that are made for use as a component of construction or repair so as to be, quote, reasonably unsuitable for use elsewhere. So this isn't just your couple sheets of sheetrock that I purchased for this project. This is a custom kitchen marble countertop that will not work at any other project. It was custom made for this project. The third type of service covers professionals such as licensed architects, engineers, or surveyors if they prepare a design, drawing, plan, plat, survey, or other specification for a project. The fourth type tells us that landscapers are also entitled to a lien if they provide labor, plant material, or other supplies for the installation of landscaping for an improvement. It also gives us some examples under this section of what landscaping work means. What is that? Such as the construction of a retention pond, a retaining wall, a berm, an irrigation system, fountain, or some other similar landscaping installation. And last but not least, 53021 tells us that it does not limit persons entitled to lien to those who construct or repair property, but also extends to individuals who perform labor as part of or furnish labor or materials for the demolition of an improvement of property. So once you've figured out if that party is even entitled to a lien, now you can begin to worry about building or deconstructing that lien and seeing if it was actually perfected. So what you're going to need to do is dig through your tool chest here and find the right tools for the job, because they vary depending on a number of things. So I assume most of us here have at least heard these first two terms: the pre-lien notice, the lien affidavit. Maybe some of us have dealt with the mechanics lien before and asked, is a written contract necessary? Do I have to have this? If you're anything like me, then when you first started looking into it, it gave you a couple chest pains, because everything seems to be an if this, then that. But when looking at these terms, what do they mean, and when and who is required to utilize these tools in perfecting a mechanics lien? So in short, the tools that you're going to need vary depending on the answers to a couple questions. So first, is the person claiming a lien an original contractor or a subcontractor? And this is going to depend on who hired that contractor, but we'll talk about that in a second. The second question is this property commercial or residential? And if it's residential, is it a homestead? Because there's additional requirements for that. So let's look at this first question here, which is just, is this person an original contractor or are they a subcontractor? So section 53.001 gives definitions for these terms, which is, again, why it's important to keep that section pulled up when walking through chapter 53. So an original contractor is defined as one who contracts with an owner either directly or through the owner's agent. So an example of an owner's agent could be a property management company or some other entity or individual, as long as they are authorized to contract on behalf of that property owner. Now, a subcontractor is one who labors or furnishes labor or materials to fulfill an obligation to an original contractor or to a subcontractor for all or part of the work required by an original contract. So in other words, if a person contracts with anyone other than the property owner or their agent, they are a subcontractor. And if the person that someone contracts with is a subcontractor, then that person is also a subcontractor. And this determination here is critical in building or deconstructing any mechanics lien, because the procedure for perfecting a lien is going to depend on whether they're an original contractor or a subcontractor. It also depends on whether or not that property is residential or commercial. So here you see the definition for residential construction project, which is a project that is for the construction or repair of a new or existing residence, including improvements appurtenant thereto, as provided by a, quote, residential construction project, which is just another defined term. And that term means a contract between the owner and the contractor, in which that contractor agrees to construct or repair the owner's residence. So both residential construction contract and residential construction project rely on the definition of the term residence. So in subchapter A, residence means means the real property and improvements for a single family house, duplex, triplex, or quadruplex, or a unit and a multi-unit structure used for residential purposes, and that is owned by one or more adult persons and used or intended to be used as a dwelling by one of the owners. So the definition of a residential construction project really hinges on the intended use of the owner of the property, not necessarily the person who may actually live in the property. And this is important because you need to be careful not to just assume that a project is residential just because someone lives there. So for example, it could be easy to understand that an apartment complex may not be a residential construction project because the owner likely doesn't live there or intend to use it as their dwelling. Rather, they just lease it out to a bunch of other people. However, you run into issues where a contractor enters a contract for construction or remodeling of a single family residence, and maybe they don't know if this person is the owner. They could assume so, but they might not know. So what we can do preemptively is just have a talk with our contractor clients and take a look at their contract that they're using and see, is there a section on there that asks, do you own this property? That could do benefits later on regarding that person's mechanics liens rights. Now, what you may be saying is, I don't see a definition for commercial project, and that's because there's not one under Chapter 53. Rather, throughout Chapter 53, it makes reference to projects other than residential construction projects. So, in short, any project that isn't a residential construction project here is going to be a commercial project. Now, before we get into the nitty-gritty of perfecting a lien, if you boil everything down to its simplest form, the blueprint for constructing or deconstructing a mechanics lien, a basic mechanics liens, is pretty simple. So for an original contractor, there's only two main steps. File that lien affidavit and then serve notice of the filed lien affidavit on the proper parties. If you're a subcontractor, you have to do those same two things, but before you do that, you have to send the pre-lien notice. So if a contractor performs these steps by the deadlines required and complies with the content requirements of the statutes, then more likely not, you're going to have a valid lien. So since that subcontractor has that extra step of pre-lien notice, I'm just going to start with them. So as I mentioned, that's the main difference between perfecting a lien as an original contractor and a subcontractor, is this pre-lien notice. And this step is critical because the Texas Supreme Court has held that a subcontractor's rights to lien are totally dependent on compliance with the statutes authorizing liens. Thus, this begins and could end potentially with pre-lien notice. Now, although substantial compliance is sufficient, a failure to send a pre-lien notice in accordance with the statutes can defeat a subcontractor's right to lien, or in my experience, at least defeat the right for them to have a valid and enforceable lien. It definitely doesn't stop them from trying, but you can't knock the hustle. So if we look to Chapter 53 here to see what is required in that pre-lien notice, here is what is provided on 53056. Now it tells you who's entitled to notice, how the notice must be sent, the content requirements, and by when that notice must be sent. So this section tells us that a subcontractor must send pre-lien notice to the owner and the original contractor. So you have to send it to two parties. This notice must be in writing and served upon the owner and the original contractor. As to what's to be included in that pre-lien notice, this section tells us that the notice must substantially comply with the form that's provided by that section. And the types of information that are included in that form are, the date of the notice, project description and address, name of the subcontractor claiming the lien, and their contact info, a description of the type of labor or materials provided, the original contractor's name, the name of the party with whom that claimant or the subcontractor contracted with, if that's different than an original contractor. And then last but certainly not least, the amount of the unpaid labor or materials that is the basis for that subcontractor's claim. Now, importantly, when sending a pre-lien notice, the section here states that a subcontractor can include an invoice or a billing statement for the unpaid amounts, but they don't have to. But if you think about it, typically it would be best practice to include that. This is just another opportunity to prove up, these are the amounts that I'm claiming, and here's proof of the work that they are related to. And I've done this work, and here's the amount, so pay me the money. But you don't have to. And on the other end of that, if you're trying to deconstruct a lien, you can always ask, do you have any invoices or billing statements for these alleged unpaid funds, right? Now, again, back to the contents, there's also some specific language that should be included, specifically if sending or when sending that pre-lien notice to the property owner. And this language states that the owner's property may be subject to a lien if sufficient funds are not withheld from future payments to the original contractor to cover this debt. So what this language does when it's included in the pre-lien notice to the owner is it triggers the fund trapping provisions under subchapter D. And I'm not going to get into that too much here because that's something that's an obligation that happens after your lien's been perfected, and we're just focusing on that procedure first. But just know that when this language is included, it's going to trigger certain obligations of that property owner. And if the property owner doesn't comply, then there could be penalties for that. And then last but certainly not least, when do we have to send these pre-lien notices? And that's going to depend again on if that project is commercial or residential. So before we get into that, let's talk a little bit more about how this notice can be sent. So 53.003 gives you insight on how that notice can be sent and also provides information for calculating the deadlines to send the notice. So first, it states that notice can be delivered in person, by certified mail, or by any other form of traceable mail with proof of receipt. And while any of these three options are permitted, I think there's benefits to some over others. So first, if you serve that notice in person, you can serve it on the party or their agent, but just consider that later on it may be necessary to prove that this notice was sent. So you might need some kind of testimony, a declaration, an affidavit, or something to get that proof there. Now, certified mail, I think, is the best option here because Section 5303 also tells you that if you send notice by certified mail, depositing or mailing that notice with the U.S. mail constitutes compliance with the notice requirements. So it's just one less thing to think about. Just send it certified mail if you can, and you're going to comply with your notice requirements. And then last, any other form of traceable mail, basically anything that gives you some kind of receipt that this was delivered. This section also tells you that in computing days in which to provide any notice under Chapter 53 or take any action required, if the last day of that period falls on a Saturday, Sunday, or legal holiday, then the period is extended to include the next day that's not Saturday, Sunday, or legal holiday. And although this provision is here, I don't rely on this. Just calculate your deadline ahead of time, and that way there's no question that you've timely complied with your pre-lien notice or any other notice that's required under Chapter 53. It's a nice safety net, but just go ahead and calculate it before if you can. And so now that we've discussed how to send this notice, let's talk about when. So for residential construction projects and for commercial projects, the timeline to send that pre-lien notice is going to vary. So again, on a residential construction project, that pre-lien notice must be sent not later than the 15th day of the second month after the month during which the labor or materials were provided or undelivered, specially fabricated materials would have normally been delivered. And for commercial projects or all other projects, it's going to be the third month, so not later than the 15th day of the third month after which the occurrence of either of those two events. So one thing to notice here is that the calculation of your deadline is not related to payment or anything else, when payment should have been received. It's focusing on when the labor or materials were provided or when those undelivered, specially fabricated materials would have normally have been required to be delivered. And so because of this, that deadline is running. So sometimes you're going to have a contractor who comes to you and says, hey, I've been working with this GC for a while. He's kind of slow to pay, but now he's really slow and I'm a little worried. I did work, I think it was 2 months ago. And alarms need to start going off in your head because the timeline to send this pre-lien notice is running, whether they know it or not. And so you need to figure out when was the last time you provided labor and materials to calculate that deadline. Now, importantly, regardless of whether it's a residential construction project or a commercial project, subcontractors have to send this pre-lien notice for each month that they provide labor or materials and then went unpaid. So for example, on a residential construction project, if a subcontractor does work in January and February and doesn't get paid for either, then they have to send notice for January's unpaid work by March 15th, and then notice for February's work by April 15th. Now, if you like to play with fire, or you just want to add some confusion in there, some people like that, you could combine these notices if you want, just as long as they were both sent by that first deadline. So you could include notice for February in January's pre-lien notice letter, as long as it was sent by March 15th. So in other words, don't be late. Early notice is fine, but don't be late. So one question that unfortunately does get asked by contractors is, hey, I missed that deadline to send the pre-lien notice. So what now? Well, typically you have two options. So first, under Section 53026A, that subcontractor may still be entitled to a lien if it can prove that the person it contracted with was what's called a purported original contractor. So 53026A says a person who labors or furnishes labor or materials under a direct contractual relationship with a quote purported original contractor is considered to be an original contractor for purposes of perfecting a lien. And this is what's known as a sham contract. So a purported original contractor is a party who is either controlled by the owner or can effectively control the owner through common ownership or voting stock or ownership interests, interlocking directorships, common management, or otherwise. And then last, if that purported original contractor was engaged by the owner for the construction or repair of improvements without a good faith intention that the parties or that the purported original contractor perform under that contract. So in this scenario, that subcontractor is going to be treated as an original contractor, which means there is no pre-lien notice. So you don't have to worry about those deadlines, but it is a little bit difficult to prove here because you do need kind of some inside information, right, on the ownership interest of the construction company or the GC and that property owner. And you got to show that relationship there. Now, in any event, the other requirements for perfecting a lien as an original contractor would still apply. So it only waives the pre-lien notice requirements. Now, your second option would be is you could still just file suit for breach of contract or other cause of action, but you just couldn't pursue your liens or pursue a mechanics lien. So the next step in that blueprint for perfecting a lien as a subcontractor, or the first step for perfecting a lien as a original contractor, is to file that lien affidavit. Now, there's three main things to remember when filing the lien affidavit. There's timeliness requirements, there's content requirements, and then sending notice of that filed affidavit to the proper parties. So as you can imagine, the deadline to file a lien affidavit varies depending on whether that property is commercial or residential, and if that person is an original contractor or a subcontractor. So if we take a look here at the timeliness requirements for a commercial project, an original contractor must file their lien affidavit with the county clerk in the county where the property is located, not later than the 15th day of the fourth month after the month in which one of these three things occurred. Either the work was completed, terminated, or abandoned. Now, if that work was completed, it's going to be pretty straightforward. The deadline is going to be, I think, easier to calculate. You run into some issues, though, if there's a termination or an abandonment, right? Especially if there's no writing memorializing that termination or abandonment. So one thing that we can do is have a talk with our contractors and have them try to create a paper trail if either of these two things occur. So if they abandon a job, so-and-so parked their Volvo for a week straight, and I told them I need to get this skid steer in there, and they won't do it, so I'm not messing with them anymore. If they're going to walk away from a job, send an email. Hey, you're in breach of contract. As of this date, I'm not coming back. And that's going to help you calculate those mechanics liens deadlines, or the lien affidavit deadline for an original contractor. Same thing with termination. If they get terminated, as awkward as it may be, if the owner gets upset with them or they get in a fight, something, that stuff happens. If it's clear, if there's a text message from the owner, hey, I don't want you working on this job anymore. Just follow up. Hey, it's my understanding that you've terminated me from this job, and as such, moving forward, I will not be working on this job anymore. So that way you'll have a confirmed deadline of when your timeline for filing that lien affidavit starts running, because it could be a fact question. So for a subcontractor, however, on a commercial project, they have to file their lien affidavit, again, after serving the pre-lien notice, not later than the 15th day of the fourth month, after the later of either the last month that they provided labor or materials, or the month they would have been required to deliver those specially fabricated materials. So again, just follow up with them as soon as they let you know. Hopefully, if you're working with a subcontractor, you're already aware because you've drafted those pre-lien notices. But in any event, just make sure that you find the last month that they provided the labor or materials. So for a residential project, for the lien affidavit timeline, the substance is the same, right? Except instead of the fourth month, it's the third month. So again, an original contractor must file their lien affidavit on a residential construction project not later than the 15th day of the third month after the month in which work was completed, terminated, or abandoned. And for a sub, again, not later than the 15th day of the third month after the later of they last provided materials or labor, or they would have been required to deliver those specially fabricated materials. So now that we've talked about when to file that lien affidavit, let's talk about the content requirements. So Section 53.054 gives you the required contents of a lien affidavit. And in any event, it states that the lien affidavit of an original contractor must substantially contain the following 6 pieces of information. So the statute actually gives you, I think it's 8 pieces of information, but some of those they don't apply to an original contractor. It's asking for if you're the original, if you're a sub, identify the party who hired you. So the first piece of information here is going to be a statement of the amount of the claim. Now, this is the actual amount for the unpaid work or materials that were furnished or provided and nothing else. So work and materials are defined terms under subchapter A. And typically, work generally is described as work that was done. Materials are described as those materials that were incorporated or used in the improvement, in that construction, not something you just bought and haven't used yet. So in other words, the statement of the amount of the claim doesn't include work that was never provided or materials that weren't used. The second piece of information there is going to be the name and last known address of the owner or reputed owner. It's simple enough. The third piece of information is a general statement of the kind of work done and materials furnished by the claimant. So note that you're not required to set forth an itemized list of every nail that you used on this project, but just a general statement of the kind of work that is the basis of this claim, right? And the statute tells us that contractors can use abbreviations or symbols that are customary in their trade, but again, just make sure that you can clearly understand what the basis is for this claim. What work or labor or materials that you provided are the basis for your mechanic's lien. The fourth piece of information there is the name and last known address of the person by whom the claimant was furnished the materials or labor to, or who they were employed by. So for an original contractor, this is going to be most often the owner. And the fifth piece of information there is a description, quote, legally sufficient for determining the property sought to be charged. So the Texas Supreme Court tells us that the general test for determining the sufficiency of a description of land is whether that tract of land can be identified with reasonable certainty. So while metes and bounds and legal definitions are best, if you don't have this, just make sure that whatever description you include identifies that tract of land that you're seeking to charge with this affidavit with reasonable certainty. And then the sixth piece there is just the claimant's name, mailing address, and if it's different, then their physical address. So the lien affidavits have to be sworn. This is typically done by a jurat at the end, but case law tells us that it is essential to swear under oath to the contents of a lien affidavit. So again, for an original contractor, here's your requirements, but for content, for a subcontractor, it's the same, but then there's 3 extra pieces of information that must be in there. So the first piece is, and you'll include this in the section when the subcontractor is describing the kinds of work and materials it furnished, but you need to include a statement of each month that you provided work or materials that for which payment is requested. So this is each month that I did work or I provided materials and I didn't get paid for. The second piece of information is going to be a statement identifying the date each notice of that claim was sent to the owner and the method by which the notice was sent. So again, this is why it's incredibly important to make sure that you comply with the pre-lien notice provisions as a subcontractor and timely send that, because if not, then not only will your pre-lien notice be ineffective, but your actual lien affidavit will be ineffective because you'll just have to admit, yeah, I didn't do it timely, or I didn't send it to the owner, I just sent it to the original contractor. And then that third piece of information there is the name and last known address of the original contractor. So after you've timely filed your lien affidavit, which complies with these content requirements we just looked at, contractors are required to serve notice of the filed lien affidavit to certain people and by certain time. So for an original contractor, they must send a copy of the affidavit to the owners or the reputed owner at the last known business or residential address, and that must include a copy of that affidavit. And they have to send this by the 5th day after the affidavit is filed. And this is a pretty short deadline. So a lot of the times, if you're seeking to invalidate an alleged lien, this is one of the first places I look because that deadline is so short. And again, that is the deadline. You can send it the same day you file it, which is probably best practice. Now, for a subcontractor, they have to send the same notice of that filed affidavit to the owner or reputed owner, but they also have to send it to the original contractor at the original contractor's last known business or residential address. Now, when speaking on homesteads, there are additional considerations for liening a homestead property, and these relate to the actual contract between the property owner and the original contractor, and then as well as some additional content requirements for any pre-lien notice that's necessary or that lien affidavit. So if we look to the contract requirements, first, in order to lien a homestead property, the contract between the property owner and the original contractor must be in writing. So while a verbal or written contract may be sufficient to establish a lien or entitlement to a lien on a non-homestead residential property and a commercial property, this is not the case for homesteads. The statute specifically states that the person who is to furnish material or perform labor and the owner must execute a written contract setting forth the terms of the agreement. Additionally, this contract must be executed before the material is furnished or that labor is provided. And if that owner, the property owner, is married, then the contract must be signed by both spouses. And I'm sure this can be a little bit awkward. Hey, I'm not hitting on you. I'm just trying to perfect my mechanics liens rights. Are you married? Because if so, I need their signature. But one thing we can do is just have a talk with your contractor clients again and take a look at the contract that they use and just add a section that says, hey, is this a homestead? And if it is, are you married? And if so, then I need your spouse's signature. And this can save that contractor later on and protect their mechanics liens rights. And then last but not least, that contract has to be filed with the county clerk of the county in which the homestead is located. So furthermore, this section tells us that if this contract is by an original contractor, then it inures to the benefit to all of the original contractor subs. So what this means, vice versa, is that if the original contractor, if their contract with the property owner doesn't comply with these extra requirements and that property is a homestead, then that subcontractor is not going to be able to have a valid lien on homestead property. Now, again, like I mentioned, for homestead property, there are additional content requirements for the subcontractor's pre-lien notice and then both contractors' lien affidavits. So that pre-lien notice has to include some additional information or language. It has to include or have attached the statement contained within section 53254G. And this is just some language that warns a homeowner that their homestead property could be subject to a lien if certain actions are not taken. And this is because Texas provides heightened protections for individuals' homestead. Likewise, that lien affidavit must also contain the language here on the PowerPoint, and this language must be stamped or typed in an equal size of at least 10-point boldface and included at the top of that lien affidavit. So because there's these extra requirements affecting liens on homestead properties, determination of whether or not a property is a residential construction project and a homestead or just a residential construction project is critical. And case law tells us that while all residential homesteads meet the definition of a residential construction project, not all residential construction projects constitute homestead properties. I'm not going to get into what makes a homestead, but just as an example, if a family owns one home and then they purchase a second home with the intention of remodeling that second home and moving in there full time and that being their sole residence, and they hire a contractor to remodel that second property, whether or not that property is their homestead is going to depend on its homestead status at the time that contract's entered. So if the family's sold and already closed on their first property and maybe they're living in a temporary housing until the contractor completes his remodel because it's never done quick enough, then maybe that second property could be a homestead. So when in doubt, if you don't know, just go ahead and comply with these extra provisions to the extent you can, because then you'll be protected. And if you don't need them, then you're fine either way because it's extra requirements. But in any event, as I mentioned earlier, Chapter 53 is only one of the sources for a mechanics lien in Texas. Now, the Texas Constitution also provides for a mechanics lien to certain individuals, but this language is provided in Article 16, Section 37, but there's key elements to a constitutional mechanic lien. So the first thing to note is that they're only available to those who contract directly with the property owner or its agent. So if you're a subcontractor, bad news. You're not entitled to a constitutional lien. Another thing that applies to constitutional liens is that they're self-executing between the contractor and the owner and are enforceable against the owner, whether or not there be notice to the owner or compliance with any statutory requisite. So again, they're going to be effective against the owner, but notice is required for a contractor to be protected against the rights of third parties. So in this scenario, case law tells us that an original contractor claiming a constitutional lien must either comply with the statutes in regards to the lien affidavit, thus giving constructive notice, or he must give actual notice to third parties within the prescribed time within the time prescribed by the statute, which I think is crazy, because how could you even know about some potential third parties and you still only have, however many months to give them that notice? So best practice here is if you're going to assert a constitutional lien, it can be effective against the owner without notice, but in order to really get the benefits of that constitutional lien and protect yourself against the interest of third parties, when you file your lien affidavit, just include another provision. In addition to in addition to claiming my mechanics lien under Chapter 53, I also assert my mechanics lien under the Texas Constitution, Article 16, Section 37. And as we draw to the end of this hour here, I just wanted to provide some last-minute considerations and some practical advice that I've learned from my experience in dealing with mechanics liens. So first, there's a couple other considerations affecting lien procedure that you should look at. The first one I wanted to talk about was contracts with lessees instead of property owners. So beware of situations in which your contractor has not contracted directly with the owner or their agent, but instead has contracted only with a tenant. So Texas Supreme Court case law tells us that a lien on real property cannot be established merely by virtue of a contract between a lessee of the property and a contractor. So if a lessee contracts for construction, the mechanics lien attaches only to the leasehold interest, not to the fee interest of the lessor. It can still be beneficial to assert a mechanics lien against a leasehold interest, because oftentimes in leases, you're going to have a provision in there that prohibits that tenant from encumbering the property or their leasehold interest with any liens. And if they do, then they'd be in default. So it kind of puts some added pressure on them to either pay your guy or for this dispute to get resolved quickly, right? Because now you're involving that property owner or their landlord. Now, another thing I wanted to bring up is retainage. So what we've just talked about today is the bare minimum for perfecting a basic mechanics lien, and applies to situation regarding liens for unpaid progress payments, not retainage, which is a defined term, under subchapter A. So if you're dealing with retainage, there could be additional language that's provided under subchapter E that may affect the timeline in regards to the lien affidavit and or that pre-lien notice requirement, depending on if that person is an original contractor or a subcontractor. So, for example, if a sub is seeking a lien only for unpaid retainage, then under section 53.052D, they have to file that lien affidavit not later than the 15th day of the third month after the original contract, the one that they are providing services for, was completed, terminated, or abandoned. So there's a different deadline there if it's just for retainage. Similarly, for the pre-lien notice, Texas Property Code 53057 gives you the information for pre-lien notice of retainage. So again, that sub has to send it to the owner or reputed owner and the original contractor, but the deadlines are different, right? The language is, it must be sent not later than the earlier of, which gotta love that, 30 days after the date the sub's contract is completed, terminated, or abandoned, or 30 days after the date the original contract is terminated or abandoned. So there's some different considerations there for retainage. Just take a look at subchapter E, and if that applies, then make sure that you're paying close attention there. Let's see what's next is after that lien's filed, priorities and preferences could come into play. So if you have any questions about that, take a look at subchapter F. Furthermore, hopefully in the event that your contractor has been paid, you'd look to subchapter G for releasing that mechanics lien, or if they haven't been paid, you would likewise look to subchapter G for causative action and foreclosure. And then last but certainly not least, just keep in mind that the right to lien can be waived, but there's strict form requirements for this. So if you cross paths with this and you have to tangle with an alleged waiver of a right to lien or a disclaimer, you look to subchapter L to see if that language complies with that form or not. And then just some practical advice here when dealing with mechanics liens with your clients. So I think the most important thing here is to just keep them in the know. Because as we've just seen, this is just a basic mechanics lien procedure that we just went through. But there are a lot of, if A, then B, if B, then C, that kind of stuff. And so there are a varying number of questions that could determine that procedure for perfecting a lien. So talk to them ahead of time about the lien procedure if that's possible. I know it's not always possible, but I think that's the most important thing that you can do to help you help them and put your client in the best position to assert and perfect this mechanics lien. And if not, then someone's going to point that out and tear your lien down. So construction clients, I'm sure we've dealt with them, or most of us have dealt with them, or maybe you haven't, but they operate in a fast-paced kind of handshake. Oh, I know this guy, I met him through so-and-so, that kind of world, right? But it's important to sit them down and have them understand that timeliness is critical when it contains or as it pertains to mechanics liens, especially if they're subcontractors. And as discussed a little bit earlier, these contractors are going to come to you possibly 2 months after they haven't been paid, or after they've completed or were terminated, or did they abandon? After one of those kinds of questions, and if it's an owner or an original contractor that they work with closely, that might cause them to wait a little bit longer, right? So, like I said, I've known this GC for years. He's always a little slow, that kind of thing. That doesn't matter, right? Because your deadline's running. So help them understand that at the first instance of non-payment, they should reach out to you and let you know. And if possible, let them know that, hey, when you start this job, start giving me this information. And then this second bullet point here, I've had contractors show reluctance to want to pursue liens on certain projects given their relationship with that project owner or the GC. They think that sending the lien notice or filing a lien affidavit is going to damage their relationship with those people. But this doesn't have to be the case, right? It's just a lawful way for your client to assert their right to payment for work or materials that they provided, right? So from a practical standpoint, the mechanics lien procedure is piecemeal. So just because you send notices doesn't mean you have to file a lien, and just because you file a lien doesn't mean you have to foreclose, right? As long as they understand that, and just understand that by sending these pre-lien notices or filing the lien affidavit timely, it's just going to help in that negotiation stage, right? Those notices don't have to be malicious. And if they truly are close with the owner or the GC, then in that scenario, they should be able to sit them down and understand that this isn't personal. It's just my way of protecting myself. And there are situations where it's a little understandable, right? If you're a subcontractor and the property owner hasn't paid that GC and therefore the GC hasn't paid you, I get it. But at the end of the day, this is my right, so I'm going to assert it. So if you phrase the discussion to your clients in a way that's focused on the contractor protecting money that's owed to them for work that they've done, they're typically going to come around and see it your way. And then last, but certainly not least, the deadlines that we've talked about today and that are identified in those statutes are the absolute latest you can send that pre-lien notice or file the lien affidavit. And it never hurts to be early. So again, help your contractor understand that they can help you help them, right? And the earlier that they give you this information, the better. And this can do wonders in strengthening the relationship between you and your clients too, because if they know that you're looking out for them before this issue even arises, they're going to be a happy customer and potentially refer you some other business. So, with that in mind, I appreciate all of you guys coming here today. And if you guys have any questions, I think Bobby's going to open up the Q&A function in the chat, and we'll see what we can do here. But if I don't get to answer any of your questions, feel free just to send me an email or shoot me a call, and we'll see what we can do. So I appreciate it. Thank you, guys.
Great presentation, Caden. We really appreciate it. There are a few questions for you in the Q&A.
Sure. Yeah, so I see the first one here. Justin, are mechanics liens allowed where there is no written contract? So I think that goes back to the person's entitled to a contract, right? That states that if they're under contract with one of these persons, so if by no written contract, or excuse me, yeah, if there's no written contract and the property is commercial, or if it's a residential construction project but not a homestead, then yeah, a verbal contract is okay. Of course, you should also be talking to your client and say, hey, man, get a written contract, right? You're providing construction services here. That's critical. But if there isn't, and the property is not a homestead, then the statutes would still permit for entitlement to a lien. Let's see, there's some other questions here. Or Bobby, I don't know if you want to pick one.
Sure, we can keep going. So Jessica Riley next asked, so a residential construction project could be on a homestead or non-homestead property, right?
Yes, Jessica, that's correct. So again, it's almost like a Venn diagram, right? All homestead properties are going to be residential construction projects, but not all residential construction projects are going to be homestead properties. And so really you get into, this is champagne problems, right? I don't, but say I have a house here and I have a house in Breckenridge. And I go to Breckenridge once a year for a month or something. That's not my homestead property, or even just to bring it back in for purposes of just talking about Texas, say I have a house in Houston. If I live full time in Dallas, and Dallas is my homestead property, a person's only entitled to one homestead at a time. So if I contract with an original contractor or a sub for repairs at the house in Houston, it's a residential construction project, but it's not my homestead, right? Because I'm intending it to be used as a dwelling, but it doesn't meet the definition of homestead property. So the answer there would be yes.
Thank you. If anyone needs to go, I'm going to go ahead and do our concluding remarks, but then we'll hit the rest of the Q&A if Caden has time. So thank you all for attending. If you do need to go, as a reminder, the CLE course number is in the chat, and have a great weekend. Caden, do you have a few more minutes to get to the rest of the Q&A?
Yeah, I have a couple questions. So as far as Catherine's, or I have a couple minutes here to answer a few questions. So Catherine, can a materialman assign his claim to a third party, and can that third party file a materialman's lien? I'll be honest, that's a little bit of a complex question with a complex answer. So shoot me an email and we'll see if we can figure out that one. Let's look at Sarah's here. It says, what happens if you file a lien, learn more information, and need to amend? Is there some easy way to fix it, or better to file a new one, assuming no prejudice for timing or other issues? Yeah, that's a great question. I guess most of the time you're gonna, I haven't actually seen a situation where you've learned information after you filed that lien affidavit, right? If you're a subcontractor, think about it this way. You send your pre-lien notice for January's work. You send your pre-lien notice for February's work. As long as you sent those notices timely, you don't have to actually file the lien until the deadline to file the lien. So that could be a couple months after that. That could be a year after that, right? After you've completed last performed labor or material. So as long as you keep working after that, your deadline to file that lien isn't necessarily going to run. So you're not really up against a firm deadline in all cases. So if you need time to flesh out more information, I think you can take a little bit of time, but just as long as you have that time under the statutes. But if you did have to amend, I would assume that you could just file an amended lien, or just serve another one as long as or file another one as long as the deadline hasn't passed. Will a video Will a video of this presentation be available? Super helpful. Thank you. I appreciate that. And yes, it's my understanding that a video will be available on, is it the DAYL YouTube channel, Bobby?
I think that's right.
Okay. And then this last question, how long after completed work must a lien be filed, not noticed without a waiver? So if we go back, I don't know if you guys can still see the slides here, but that's going to depend on the answer to a couple questions. So again, it's going to depend on, is the property commercial or residential? And is that contractor an original or a subcontractor? So if they're a commercial project and it's original contractor, then again, it's the 15th, not later than the 15th day of the fourth month after the month in which that work was completed, terminated, or abandoned. And if it was a subcontractor, then it's not later than the 15th day of the fourth month after the later of the month that sub last provided labor materials, or they would have been required to deliver that specially fabricated materials. For residential properties, the lien affidavit filing deadline is substantively the same, but it's 1 month earlier. So that'll answer your question there, and that's section 53052 for that last question.
Great. Caden, thank you again. Everyone, hope you have a great weekend.
Appreciate it. Thanks, guys. Everybody have a good Friday.